Please be seated. Thank you.
Ladies and gentlemen, can I have your attention at this time? At this time, I'm going to have everyone check their cell phone. Make sure your phone is on silent or off. If your phone goes off in the courtroom, I will ask you to leave. If you want to use your phone, you have a courtroom right next door on a rollover room. So if you want to use your phone on that one, there was no eating, sleeping, and no talking in the courtroom. This is the only warning I'm giving you. We have to tell you, take your cell phone out, and we get you talking, we're going to have to leave. Thank you, Your Honor.
Thank you. Mr. Marshall, would you approach, please?
Yes, Your Honor.
This is the matter of State of Connecticut versus Michelle Troconis. May the court have the appearances of the parties, please.
Good morning, Your Honor. Michelle Manning for the state.
Your Honor, good morning. May it please the court. Sean McGinnis for the state.
Good morning, Your Honor. Attorney John Schoenhorn representing Michelle Troconis, who is seated to my left. Michelle. Thank you.
Good morning, Your Honor. Audrey Felsen for Michelle Troconis.
Thank you. There were a number of motions filed yesterday, and there were a number of motions filed today by the defense. What the court intends to do is just indicate what those motions are. The court will not act on all of those motions today. Filed January 10th, 2024, motion for sequestration of witnesses. Now, the court will act on that motion today. So what the court will do is just hear from Attorney Schoenhorn on that motion.
I ask that the court grant that motion as a matter of course, and it would apply to both sides.
Does the state wish to be heard?
Yes, Judge. Good morning.
Good morning.
Well, Your Honor, the part of my issue with the defense's motion has been alleviated by Attorney Schoenhorn's representation that it would apply to both sides. So with that, obviously, we don't have any objection to the law enforcement personnel and most of the witnesses being sequestered. However, there are members of the Farber family, Your Honor, who wish to be present that are potential witnesses in this case. And I'll just direct the court to State versus Swinton, which is 268 Con 781. It's a 2004 case in which the trial court indicated when there's a request for the victim's family to remain that it would balance the interests of both parties. Specifically, I believe that a fair reading of Swinton is that the defense needs to identify specifically which members of the victim's family they want excluded, and I think the court needs to balance whether or not their presence during particular portions of testimony could potentially influence their trial testimony. And so I think following Swinton, Your Honor, it's incumbent upon the defense to identify specifically who from the victim's family they want excluded, and then I think they need to make a proffer as to how their testimony can be influenced. So we would ask that the court grant the motion with the caveat that the victim's family be allowed to remain in the courtroom.
You wish to be heard, counsel?
Yes, twofold. The first is, I do not know what the family is going to testify to. So it's incumbent upon the state to make a proffer. How am I to make a proffer as to how it will be influenced by other people's testimony unless I know that? So I think that he's put the cart before the horse. If the court were going to, however, consider that a request by the state, which is it's discretionary, but it also goes to the issue of a fair trial and due process, they would ask the same for my client's family. As the court is aware, the court has already heard during pretrial hearings from my client's mother, who's present in the courtroom, and if something arises where she might have to testify to some of the matters that she was actually present for, I would ask for that same consideration. But until the state indicates the nature of the testimony, if in fact it does not involve any evidence that would be influenced by someone else, that's a little bit different but the normal procedure is that all witnesses that are going to be called are sequestered, and that was what we would do if we were going to call any of the members of the family ourselves. Thank you.
Counsel.
So just briefly on that, Judge, that's incongruent with Swinton, which I've cited to the court. I think it's incumbent upon the defense to indicate why they think a victim's family needs to be excluded from the courtroom. And the difference, of course, here is that the defendant's family and the victim's family are not similarly situated. Article 8 of the Connecticut Constitution specifically delineates certain victims' rights, including the right to attend court proceedings. And so therein lies the difference between the Farber family and the defendant's family. So I agree the defense witnesses should be excluded, but the Farber family should be allowed to remain.
Thank you. Well, it is clear that there are competing interests. However, there is constitutional provision that would allow, and this court will use the term according to the constitutional provision, would allow the victims to be present at every stage of the proceeding. That does not mean the victims can be heard at every stage of the proceeding. So the court is going to deny the defense's request that the state identify the members of the family and the nature of the testimony it intends to elicit. However, the court will grant the balance of the motion, indicating that no witness who testifies will be allowed to discuss their testimony after that testimony has been elicited with any other witness who has not yet testified. Filed January 10th, 2024, a motion in limine to preclude hearsay statements by third parties without determination of co-conspirator status. The court believes it does not have to rule on that today. Also, there was a memorandum in support of that motion. January 10th filing 2024, motion in limine regarding prior bad acts of the defendant. Well, the court probably is not going to anticipate that testimony to come forward today if it were going to be elicited. Probably not today, is that correct?
That's correct, John.
Thank you. Filed January 10th, 2024, motion to preclude layperson testimony regarding cellular site location and geofence evidence. That testimony is not likely to be elicited today, correct?
That's correct, Your Honor.
January 10th, 2024, motion in limine to preclude pejorative reference to written timelines. That is not going to be elicited today, correct?
That's correct, Your Honor.
Filed January 10th, 2024, motion in limine to preclude references to victims. Well, that probably is going to be woven throughout the trial. So the court will hear from Attorney Schoenhorn.
Yes, I believe that the case law that I cite in here, particularly the Warholic case, is on point that the state has to prove that that Jennifer Doulos was a, quote, victim, unquote. Whatever position we may or may not take, whatever we may think about it, it is something that has to be proved. The case law is clear that unless we stipulate or agree that someone constituted a, quote, victim, unquote, and I would note, I'm not raising that with regard to the Farber family. They have an interest in the matter for the time being, but that's something that has to be proven by the state. At this point, there is no such evidence, and the bottom line is that there have been many cases that have resulted. It's either reversible to allow the state, or for that matter, the court, to refer to any party or any individuals discussed as a, quote, victim, unquote, or it might be harmless error in certain cases, but it's still error. So I want to just make sure that that is not something that gets slipped, and that's why I'm filing it as a motion. It might be accidental, but the bottom line is I don't have any problem with people discussing her by name. They can refer to Miss Doulos. They can call her Jennifer Doulos. They can call her by her first name, or the missing person. What I'm concerned about is starting off suggesting that she's, quote, the victim, unquote, in this case. Might be different if this was Fotis Doulos' trial, but it's not.
I'm hard-pressed to see how it would be any different in any trial. The law is the law on this, Judge, and I think we did this dance during voir dire a little bit. The state intends to refer to Ms. Farber Doulos as either her name or potentially the alleged victim during the course of the trial. And I would just direct the court to State versus Warholic, which is the case that the defense cited, and Warholic specifically, along with State versus Smith, which is cited in Warholic, permits or tacitly indicates that the use of the term alleged victim is different than the term victim itself. And so we are going to be referring to her at times as the alleged victim. We think that that's appropriate. It's alleged in the information that she is, in fact, the victim. And so that's how we're going to conduct ourselves during the course of the trial.
Thank you. The court is going to read the information to the jury, and that information is going to include language in reference to the name Jennifer Farber Doulos. The designation as an alleged victim would arouse no prejudice. So the reference to victim itself is frowned upon, but alleged victim is acceptable. So the motion is essentially granted in part. January 10th, 2024, motion in limine to preclude law enforcement opinion regarding the credibility or truthfulness of the defendant. That testimony is not likely to be elicited today, correct?
That's correct, Your Honor.
Thank you. Filed January 10th, 2024, motion in limine to preclude reference to the defendant's assertion of her Miranda rights, including request for presence of counsel. Attorney Schoenhorn.
During the hearing on the interrogation videos, portions were played by the state involving the trip from the time of her arrest, where they tried to get her to waive her right to counsel. She said, no, I want to speak to my attorney. And then there's that middle of the night, I'll call it interrogation. They want to just call it, making sure that Ms. Troconis is all right. But again, where she asserts her right to counsel at that point. I'm assuming, but I don't know, that the state does not intend to offer those, any audio portion of those recordings. And I assume that if anything they're going to play begins in the afternoon, where Attorney Bowman is present with Ms. Troconis. This is to make sure that that doesn't suddenly come in either through a witness or through the accidental playing of that video.
Good morning again, Judge. Just a couple of things on this. Firstly, I hadn't anticipated that we were going to be hearing argument on this particular motion today, just because I think we're several days away from introducing any portion of the defendant's recorded interviews. But I'll just note for the record that it is inaccurate when the defense says that there's no probative value whatsoever to an invocation. In fact, our case law permits an invocation to show the sequence of events. Now, it can't be used by the jury to draw an adverse inference of guilt. That I agree with them on. But I'll note the interpreter who is translating what I say to the defendant's ears right now. And I raise that, Judge, because if there's going to be any sort of claim during the course of cross-examination or the trial that the defendant did not understand her Miranda rights, and the fact that she invoked multiple times to the police in advance of that interview, which we're going to be playing, then we think that the defense opens the door to all these issues in terms of rebutting the inference that she didn't understand her rights. And so I would ask the court not to act on this motion now. I think this issue is going to be fluid, but I disagree with the defense that an invocation could never come into evidence, because that's simply completely contrary to the case law.
Thank you. Again, this testimony is not going to be elicited today. The court would also indicate that the court denied the defense's motion to suppress those 8 hours of essentially interrogation by the police of the defendant. January 11th, 2024, filed today. Motion in limine to preclude the use of inconclusive and, in quotes, cannot be eliminated, end quote, DNA results. That's not likely to be elicited today. January 11th, filed today. Motion to preclude irrelevant videos or opinion of unidentified bicyclist. Is that unlikely to be elicited today?
Judge, it is, and can I just have a moment to consult with Attorney Schoenhorn, because we don't have copies of these.
Yes.
No, I believe
I don't have them.
they're here.
Yeah, I wasn't sure which ones were.
Judge, may we take up the motions that were filed today, perhaps at a break, or if the court wants to know what they are for the record, of course. We don't have copy right now. So.
Thank you. Court still wants to put on the record what was filed today. And we need not, because the state is just receiving copies, we need not take up any of the balance of the motions. Filed today, January 11th, 2024, motion in limine to preclude all evidence of alleged domestic discord between Fotis Doulos and Jennifer Doulos. Filed today, January 11th, 2024, motion to preclude videos or opinions of unidentified red truck. Filed today, January 11th, 2024, motion in limine to preclude speculation, lay opinion, and prejudicial descriptions of blood-like stains. Is that likely to come in today?
Yes, Your Honor, that is likely to come today. May I have a copy of that?
Attorney Schoenhorn, do you wish to be heard?
Yes, I mentioned when I met with the state yesterday afternoon that I was working on that motion. This motion is in conjunction with there's two motions. There's the presumptive blood testing evidence and this motion together. I cite the same case, State versus Moody, and I'll just quote, because I quoted in my motion. It specifically says, the result of the presumptive test for blood has no probative value whatsoever. The test result did nothing toward establishing the likelihood of the presence of human blood. In that case, I put in brackets, it's on a piece of clothing. Therefore, we hold that the test result was entirely irrelevant, and thus the trial court abused its